This is a revocation of a very unsuccessful probation, Mr. Tilcock. Of course, it's not going to just let you schedule it down the line when it's convenient. I do understand that you want to complete a job. I get that. But you need to go ahead, do that short amount of time, and then be released back free of any obligations under this probation order. With Brett Sweeney appearing for the state, James Watts as defense counsel, Mr. Tilcock now appearing at the court security Zoom location at the Butler County Judicial Center. This matter is before the court at this time for review of probation. Warrant to show cause would indicate certain violations have been alleged. And I trust we're looking at the request that was filed in the court October 1 of 2025. Failing to pay as directed, failing to report, failing to complete BIP recommendations, and apparently a violation of a no contact order with an alleged victim. What are your client's intentions here, Mr. Watts?
Your Honor, I spoke with my client on the matter. As to the first allegation, did not report until a letter was sent. My client would acknowledge that is true and waive hearing. As to the second, had not made a payment since till September. He would acknowledge that is also correct. However, I would also note that the narrative that goes with the warrant to show cause indicates that at that point he paid a $260 payment on it, so a substantial payment. Has not started banners intervention classes. My client would note that is correct. The transportation issue has been very difficult to do and has had ongoing contact with Shonda Patton, the named victim in this matter. My client would acknowledge that is the case. He would also tell the court that most of that contact was initiated by Ms. Patton rather than himself. I know that doesn't make a legal difference, but I think as a factual matter. So he would stipulate to the violations and waive hearings.
Tilcock, you've heard your attorney's announcements. Do you agree with them?
Yes.
Okay, so you understand that you do have a right to a due process hearing where the state has the obligation of proving these allegations. Do you understand that?
Yes.
And that you can challenge the state's evidence with the assistance of your lawyer, present your own evidence, and confront the state's witnesses unless good cause was shown. You understand that?
Yes.
You understand that the court, among other lesser remedies, could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up?
Yes, Your Honor.
All right. So do you waive a hearing and stipulate and agree that you committed these violations as outlined on the record here?
Yes.
Very well. Court finds that the defendant has knowingly waived his right to a hearing, stipulates and agrees that he committed all four violations, which were identified earlier by the court and Mr. Watts. These are substantial and material violations of the terms and conditions of probation. Court wants recommendations regarding an appropriate disposition. We'll start with the state's attorney, Mr. Sweeney.
Thank you, Your Honor. Your Honor, I show this as a 30-day underlying jail sentence with probation. Some of what's been stipulated to today are, as the court's already noted, substantial, but pretty fundamental to his probation as well. He does have 21 days of jail time credit, so the state's asking for a revocation of probation in the service of sentence, which we believe to be 9 days left on that 30-day underlying.
I understand your position, Mr. Sweeney. Mr. Watts, what is the defense position?
Well, Your Honor, we came to a similar conclusion. There's a 30-day underlying sentence here. The probation officer in his narrative notes that he has 20 days jail time credit. If you look on further up, it looks like there's another 48 hours he served in September of this year. So I think I have 8 days, but either way, 8 or 9 days of time that is left on the underlying sentence. It is my understanding, speaking with my client, that he wishes to simply serve out that remaining time. We do not believe it is very long, and close this matter. It's my understanding my client is currently working a job. He expects to have that job done by the middle of next week. He would ask to be able to report once that job is done by the end of next week, if the court is willing to let him do that.
What would the state's position be on that request, Mr. Sweeney?
Generally, Your Honor, the state's position, and I think in this case as well, is that we would object to that and would ask for service of time forthwith.
Chilcock, is there anything that you wish to state to the court in mitigation of punishment here?
No.
Okay. Before we go any further with this, I want to have a clear-cut determination as to what his accrued jail time credit is. Again,
Your
even
Honor.
1 day is a big deal to him.
Mhm.
So
Your Honor, I apologize. I have a
go ahead.
on my affidavit, the 48 hours that Mr. Watts referred to, that is where he texted the victim, told her he served 48 hours in jail. However, he was
Okay.
never arrested in September for that. That's just where he told her he had. I'm not sure if I had that in quotes or not, but that was actually a quote from a message that he sent to her saying he did. However, he didn't serve any time on this case after his sentencing until he was picked up on the warrant, and he has 1 day for that.
So that being the case, Your Honor, it sounds like Mr. Sweeney's computation would be correct.
Yeah, I got two different computations. One says 130 to 219 and another one says 129 to 219. Obviously, the one that shows him booked in on the 29th would be 21 days of jail time credit. So, yeah.
Can I make a suggestion, Your Honor?
You can make a suggestion.
I'll do 10 days flat out.
Okay, well, you'll do what's appropriate. It is the intention of the court to do an outright revocation of probation in this case in order to serve Mr. Tilcock to serve the remaining balance of the 30-day jail sentence originally ordered. Do we have concurrence that the proper jail time credit would be 21 days?
I think that's accurate, Your Honor.
That sounds correct, Your Honor.
Well, the
I
court's
believe
going to
that-
order Mr. Tilcock into immediate custody of the Butler County Sheriff's representatives until his custody can be transferred to the Butler County Jail. This is a revocation of a very unsuccessful probation, Mr. Tilcock. The court's not going to just let you schedule it down the line when it's convenient. I do understand that you want to complete a job. I get that. But you need to go ahead, do that short amount of time, and then be released back free of any obligations under this probation order. However, you will still owe the amounts owed in the case. If they haven't been turned to collection, they will be turned to collection at this point as being immediately due, payable, and collectible. I'm not going to assess anymore, though, under the factual circumstances of this case, but only what was ordered prior to today. So 9 more days, Mr. Tilcock. There's nothing further then. The Tilcock matter, I believe, is concluded. We can move on to another case.